Hi Mike, hi Al, hi Gail, Captain Lee fan listening from the tub. I'm gonna go to the YouTube streets here so I can. I think this is my live. Make sure that we're live. Um, so we're gonna go through Bryan Kohberger again. I just want to just talk about Gene Hackman and his wife because they have a cause of death now. It's the hantavirus for his wife. I'm sorry, my shoulders and everything are disappearing. Is the hantavirus, and that's a virus from rodents, from rodent feces or urine, and it's a very rare virus. But apparently, that's what she passed from. Hi, Rosalita. And they said that she was deceased before him. He was in the very late stages of Alzheimer's, and so he had also a bad heart. He had a pacemaker, and so when they found him, she was his caregiver. She was like 30 years younger than him. And the dog had had a procedure as well. So, yeah, a really sad. And they said that he had a cane and it looked like he was heading for the door, maybe trying to get some help. But again, he had that really, really late stage dementia. So it's odd, right, that she died where she died, but that is what they found on the autopsy, is the hantavirus. And he probably, didn't know. They just assumed he was there for, 7 to 9 days? Because the last activity from her, I believe, was, did they say the 11th? So yeah, sad. Okay, but it wasn't just sad. I've heard so many different theories on this, from like the mob hits to kids, but no, it's hantavirus. Believe that or not, mice feces or urine. And then he had no caregiver. I'm surprised he didn't have a life alert or something. Too bad he didn't have a life alert to try to get that. Why they didn't have any help? Yeah, I don't know. Who knows, right? All right, so there's a lot of stuff on Kohberger coming out now. I will say that Stephen Gonsalves went on News Nation and said that they were completely blindsided by all the stuff that's come out. They got no advance notice of any of it. They didn't know about any of it. And regarding the roommates, he said, at first he doesn't even know why this was kept for so long. Hi, Slam RN, yeah, right? Why it was kept for so long, and that these poor girls are going through hell because they're being scrutinized and all this stuff about these things. And then, we don't know why they did what they did. It's so important to call your parents every single day when they are elderly. Yes, Rosalita, absolutely. Absolutely. Be blessed if you have parents, I mean, there are people that I know that are older than me that still have their parents. Like, Scooter has her father, and somebody else recently that had. They have both parents. Oh, my cousin, who's older than me, 10 years older than me, has his mother, and has father until 17. So yeah. So yeah, if you're blessed to have your parents, call them. Call them. Okay, so let's talk about Kohberger, because there's a lot more stuff coming out and stuff that's in these documents, and so we're going to continue to go through them. Let's see. Okay. So some people are getting scared. They're thinking that, oh, when they talk to her father, they say, well, like, what is all this that you can't say murderer, you can't say psychopath, you can't say sociopath, you can't say murder weapon. Like, it's just craziness in there, isn't it? And then the autism. Oh, and they killed that guy in South Carolina with the firing squad. Did you guys hear that? They killed him with the firing squad. A little after 6 o'clock tonight, I believe it was. Okay, hang on here. I'm just trying to see if anything, if people are... Oh, somebody's saying that people are getting subpoenaed for their comments in Facebook groups. Come on, please. All right, let's... Let me go to where my Idaho files are. Okay, here they are. Oh. All right, so we were, I think, over here. Maybe we were on this one. No, we were in the middle of one, I believe. Let me see. I've got them. I still have them up. It wasn't that one. Let's see. Guess it's gotta be here. There we go. Let's see what we've got here. These were the witnesses. We went through that. And we went through that one. I think we were... Because there's certain ones that talk about a vacuum cleaner. Have you guys heard this thing? That Dylan had said he was holding something like a vacuum cleaner part. And I did put that out here, the one that says that. Now let me get that. Let me see here. Vacuum cleaner. Okay. Okay. Dylan had stated that she witnessed Bryan Kohberger carrying a vacuum-type object, but there's a lot of controversy stating it might have been the K-bar knife or possibly a stun gun, but unfortunately there's no accurate description. Okay, so let's try to see where this is and see this for ourselves. So I did take the... It's from the denying of the Frank hearing that I have to go to see. Let's see. All right. Okay, hold on, I've got the index and I'm trying to get this up here. This is... I don't know why I'm so sorry. I just... Okay. Idaho Supreme Court. Okay, I'm so sorry. Go on. All right, so let's see. Somebody... Oh, there it is. I am so sorry. Okay, I've got it. I'm really sorry. I've had a tough day, guys. I've had a tough day. But I'm going to be okay. Let's see here. So let me go to request to leave to file expert witness disclosure. Filing signed and notarized affidavit. Okay, I'm going to get the... Which one did I say it was? It was the... one about the denial of the Franks hearing. Okay. Here we go. I've got it. Thank you for hanging with me if you did. Appreciate that. All right, here it is. Let's take a look at this. This is supposed to have our vacuum cleaner stuff in it. The defendant is charged with one count of burglary. We know all that. Okay. Let's see. And now it says, okay, for a search warrant to be valid, it must be based on probable cause. We have the Franks hearing on this channel. We broadcast it, streamed it. Defendant has not met his burden under Franks on issues 1 and 2. First, it is not improper for law enforcement seeking a warrant to swear to matters with the collective knowledge of other officers involved in the same investigation. Second, the defendant has not demonstrated in his proffers any misrepresentations or omissions, much less that they were made intentionally or recklessly or had any effect on probable cause. It is well settled that statements of law enforcement officers that are based upon the observations of fellow officers participating in the same investigation carry a presumptive of reliability. Defendant acknowledges that a warrant can be based on law enforcement's common knowledge, but argues that officers cannot sign a collectively drafted affidavit as their own without identifying who did the work described therein. Otherwise, it misleads the magistrate into believing that the swearing officer drafted the affidavit and performed the work therein when it was a collective effort. The hyper-technical argument has no traction under Franks. Even if a search warrant affidavit does not specifically identify the precise source of the information from within law enforcement, it is still sufficient to support probable cause if a reader would reasonably infer that the information came from other law enforcement personnel. For example, the defendant challenged an officer's search warrant affidavit on the grounds that the swearing officer did not identify which facts were based on his own personal knowledge as opposed to hearsay information from other sources. whether he had personally viewed the evidence, the source of information for the drugs dogs training and experience, and the identity of sources he contacted for the information, noting that search warrant affidavits are not to be reviewed and tested in a hyper-technical manner. The Idaho Court of Appeals rejected the defendant's argument, finding that a common-sense reading of the affidavit could allow the magistrate to reasonably infer that the information came from the officer's own observations or those of other officers engaged in the investigation. Here, the defendant's evidence demonstrates there were several law enforcement agencies working together in this case, including the Idaho State Police, the Moscow Police Department, and the Federal Bureau of Investigation. Okay, so let's see. Okay, here we can go here. Importantly, the exhibit as challenged by defendant included statements alerting the magistrate that the affiant was assisted by other law enforcement agents and that the information contained within the Exhibit A was based on information provided by these other agents. Okay, so let's see. Here's the first misrepresentation identified. Is an issue 2 is contained in Blaker. Let's see what they said. This is about the knife sheath. Okay, it says, Exhibit A supporting the warrant application for defendant's Pullman, Washington apartment and his office at Washington State University. The defendant claims that Sergeant Blaker attributes discovering the knife sheath to the Idaho State Police officers rather than Detective Payne. However, as the state correctly notes, defendant's challenge is nothing more than a quibble over semantics. Exactly. When Sergeant Blaker stated was, I was later advised by ISP investigators that they located a tan leather knife sheath laying on the bed next to Mogan's right side. In fact, it was Detective Payne who was the first investigator to discover the knife sheath. Once discovered, Detective Payne notified ISP investigators who then collected and booked the sheath into evidence. So they said that's the problem, but they're saying, no, that doesn't mean anything, okay? Trying to see where the vacuum comes in here. In issues 3 and 10. Okay, yeah, it's probably here. Okay, so in issues 3 and 10, the defendant challenges that probable cause statements insofar as they set forth Dylan's interview descriptions of things she heard and saw on the night of November 13th, 2022. The defendant claims that law enforcement failed to inform the magistrate that Dylan's accounts describing the suspect were variable, and that she questioned her memory, and that she did not recognize the defendant when provided with a photo of him after his arrest. The defendant also contends that law enforcement misrepresented statements made by Dylan that would have demonstrated her unreliability. These allegedly false statements and omissions, according to the defendant, were exculpatory and material. While defendant's challenge may be fodder for cross-examination, it is not the proper subject of a Franks motion. Defendant's own proffer establishes that Dylan's accounts were remarkably consistent throughout her multiple interviews with law enforcement, and further, the probable cause affidavits are very consistent with her accounts. Second, Dylan's interview statements that her memories were fuzzy and dreamlike may have been affected by being tired or under the influence of alcohol, and they do not call into question her reliability to the extent that Franks would require disclosure. Finally, Dylan's failure to recognize the photo of the defendant is of no consequence, given that the intruder she saw was masked. Dylan's accounts were consistent and accurately summarized in Exhibit A. The draft Exhibit A, circulated by law enforcement, included the following description statements made by Dylan during her interviews with law enforcement. So Dylan made statements during interviews that indicated the occupants of the King Road residence were at home by 2 a.m. and reportedly asleep by 4 a.m. This is with the exception of Xana Kernoodle, who received a DoorDash order at the residence at approximately 4 a.m. Dylan stated she was awoken at approximately 4 a.m., but what she stated sounded like Gonsalves playing with her dog in one of the upstairs bedrooms, which were located on the 3rd floor. A short time later, Dylan said she heard who she thought was Kaylee Gonsalves say something to the effect of, "There's someone here." A review of forensic records associated with a download of Kernoodle's cell phone indicated she was likely awake and using the TikTok app at approximately 4:12 a.m. Dylan stated she looked out of her bedroom but didn't see anything when she heard the comment about someone being in the house. Dylan stated she opened her door a second time when she heard what she thought was crying coming from Xana's room. Dylan said she heard a male voice say something to the effect of, "It's okay, I'm going to help you." At approximately 4:17 a.m., a camera at 1112 King Road picked up audio of what sounded like a struggle coming from off-camera. The security camera is less than 50 feet from Xana's bedroom wall. The struggle lasted less than 1 minute, and unintelligible sounds can be heard on the camera. Dylan stated that she opened her door for the 3rd time after she heard the crying and saw a figure clad in black clothing and mask that covered the person's mouth and nose walking towards her. Dylan described the figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. The male walked past Dylan as she stood in a frozen shock phase. As the male walked towards the back sliding glass door, Dylan locked herself in her room after seeing the male. This portion of the draft Exhibit A was incorporated in varying degrees into Blaker's Exhibit and Mulry's Exhibit. When these Exhibit A's were submitted in support of search warrant applications, Dylan had sat for at least 3 interviews with law enforcement, 2 on November 13th and 1 with Officer Nunes and later with Detective Mallory, and 1 on November 17th with Detective Goach. And her description of the intruder was notably similar during all 3 interviews. White, male, slim, skinny, lean body type, slightly taller than Dylan, 5'10", wearing all black, wearing a mask that was covering his forehead and his mouth, a voice that she didn't recognize, saying, "Here to help," and the intruder walked out or towards the back sliding door without saying anything to her. While she did not tell Officer Nunes that she noticed the intruder carrying a vacuum-type object in his hand, she did convey that information to Detective Mulry the next day, as well as to Detective Goach a few days later after that. She also told Detective Goach that she remembered the suspect's eyebrows were bushy, but couldn't remember their color. Likewise, she told Detective Mulry she could not remember the color of his eyebrows. Most importantly, not only are Dylan's statements consistent with each other with regard to the intruder's description, they were accurately included by law enforcement in Exhibit A set forth above. There is not one statement in the affidavits regarding the intruder that cannot be traced directly to Dylan's words. Consequently, the defendant has not demonstrated an intentional or reckless false statement or omission of a material exculpatory fact with regard to law enforcement's recounting of Dylan's descriptions of the subject. Defendant also asserts that Exhibit A watered down Dylan's statements about hearing Kaylee Gonsalves around the time of the homicides. According to the defendant, Dylan was unequivocal in her 3 interviews where she reported that at about 4 a.m. she heard Ms. Gonsalves walk upstairs with her dog before running back downstairs, saying, "Someone's here." In draft Exhibit A, however, law enforcement represented that Dylan said she heard who she thought was Gonsalves say something to the effect that there's someone down here. There's someone here. Right? Hang on 1 second. Hold on, guys. Just one little moment. I forgot to put my link over here. Just want to put a link to my video. Okay. So Miss Gonsalves walk upstairs. Okay. That they watered down, right? Where were water? I knew that. Someone's here. However, law enforcement represented that Dylan said she heard who she thought was Gonsalves say something to the effect of, "There's someone here." Defendant argues the addition of the word thought is false, and further, defendant surmises it was intentionally false to cover up the fact that Dylan was wrong about what she heard. The defendant points out that Miss Gonsalves was killed in the upstairs bedroom where she was found the next morning. Thus, it could not have been her who Dylan heard running down the stairs at 4 a.m. The defendant contends that Dylan's misperception, had it not been covered up by law enforcement, would have cast doubt on her reliability and therefore probable cause. However, the statement challenged by the defendant can be read in two ways. That Dylan said, "I think it was Ms. Gonsalves," which is how the defendant apparently reads it, which he claims is inconsistent with Dylan's interview statements, or that Dylan said she heard Ms. Gonsalves, but law enforcement had reason to think it could have been someone else. When the statement is viewed in context, the latter makes more sense. In their respective Exhibit A's, Detective Payne and Sergeant Blaker immediately followed up the challenge statement with the following. A review of records obtained from the forensic download of Kernoodle's phone showed this could also have been Kernoodle, as her cell phone indicated she was likely awake and using the TikTok app at approximately 4:12 a.m. Through this explanation, Payne and Blaker are effectively conveying to the magistrate why they believe Dylan's statement of who she heard was questionable. Thus, the court cannot conclude there is anything false or misleading in this regard. In addition, even assuming it was a false statement, the defendant has not established that it was an intentional or reckless attempt to hide Dylan's alleged misperception, or that her actual statement was exculpatory or otherwise material to probable cause. Consequently, a Franks hearing is not warranted with regard to statements in the relevant Exhibit A's regarding Dylan's account of what she saw and heard. There is no evidence law enforcement intentionally or recklessly omitted information bearing on Dylan's reliability, or that such omissions were material to probable cause. Defendant next asserts that the probable cause statements omitted important information bearing on Dylan's reliability. The defendant notes that Dylan qualified her interview statements on several occasions by questioning her memory of the event. For example, she told Detective Mulry, "Everything was kind of blurry, like I don't fully remember it. I would say..." A few days later, while recounting the events to Detective Gooch, Dylan stated, "Again, I believe I was also very drunk. I don't know how much of this is real. Like, I don't know if my mind was like doing whatever. I don't know any of it. Like, half this stuff, I don't know if it's a dream or if it's real. I just have no clue." She also said her memory was fuzzy and cloudy, and she could not differentiate if anything is real or if it is a dream. This information was not included in Exhibit A's. According to the defendant, the information was crucial to allow the magistrate to properly evaluate Dylan's reliability, and its omission was material and exculpatory. The law does not favor the defendant on this argument. Probable cause is determined by examining the totality of the circumstances and making practical common sense decisions, whether giving all the circumstances set forth in the affidavit before the court, including the veracity and the basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. Okay, let's see here. None of Dylan's qualifications during her interviews reasonably placed her presumed reliability in dispute. She was a direct witness and was able to consistently articulate the details she remembered throughout each interview, especially as to the facts relied on in the search warrant affidavits. Despite the fact that she claimed her memory was fuzzy, or that she felt like it was a dream, or that she was still intoxicated. Further, even if her reliability were in question, there was other evidence included in Exhibit A that corroborated her account. For example, the security camera from 1112 King Road picked up audio of a struggle at 4:17 a.m., which coincides with when Dylan stated she thought there was crying coming from Zena's room, and a male voice speaking. It was shortly after this she opened the door for a third time and saw the suspect walk by her towards the sliding glass door, which corresponds with the surveillance video showing the suspect vehicle leaving 1122 King Road at 4:20 a.m. In addition, law enforcement corroborated Dylan's description of the defendant through its vehicle identification efforts, which led investigators to the defendant's driver's license information. The Exhibit A's noted that the defendant's physical description was consistent with Dylan's account. Defendant has shown no objective indication that Dylan's interview statements were unreliable, particularly given the other corroborating evidence, and therefore no reason for law enforcement to include her qualifications in the affidavit. For this reason, it cannot be said that law enforcement intentionally or recklessly omitted the information. Further, the Exhibit A's inferred that Dylan was traumatized when they noted that she stood in a frozen shock phase when she saw the intruder. This necessarily alerted the magistrate that Dylan's memories were colored by trauma and shock, which goes to the issue of her reliability that defendant targets in this motion. Finally, even had the Exhibit A's included Dylan's qualifications to her memory, it would not have significantly undermined her credibility and would not have negated probable cause. It would be no surprise to the magistrate that a person experiencing what Dylan must have experienced would be shaken by what happened and would have questioned the reality of what she perceived. This does not render her unreliable. Additionally, the bulk of probable cause came from other sources, including the extensive vehicle identification efforts. Thus, even if the magistrate questioned the reliability of Dylan's account, she had sufficient grounds through other evidence to issue the warrants. In sum, the defendant has not shown that Dylan's various qualifications to her memory are material exculpatory facts that were intentionally or recklessly omitted and that would have affected probable cause. It is evident from the applicant's exhibit as that Dylan's account was largely relied upon to establish the timing of the homicides and a general description of the perpetrator, not to identify the defendant specifically. Her statements on these matters were consistent. While any perceived weaknesses in her memory may be fodder for cross-examination, they do not negate probable cause. Consequently, a Frank's hearing is not warranted. Dylan's non-recognition of defendant is immaterial. Defendant also contends that law enforcement's failure to include Dylan's non-recognition of defendant in the Exhibit A warrant of a Frank's hearing. An Exhibit A warrants a Frank's hearing. During her December 30th, 2022 interview with law enforcement, Dylan was shown the defendant's mugshot and asked by Detective Lake whether the defendant was the person she saw in the house, and Dylan responded, "I have no clue. From what I remember, I just remember seeing this figure that was more or like the skinnier tone build and some mask on. I don't know if it was covering his mouth, his nose, or below his mouth and nose. I just remember he was white. But I didn't know how he was white. I just knew he was. And I know he looked at me because of the bushy eyebrows. However, the fact that Dylan couldn't identify the defendant is hardly exculpatory or material to probable cause. Her statements, her interview statements, consistently described a black-clad, masked person who was not someone she thought she knew or could identify. Her inability to recognize the defendant, unmasked, is expected, particularly where her description, as relayed in the Exhibit A's, describes a mask that covered the person's mouth and nose. Thus, because her non-recognition is not material or exculpatory, the defendant cannot demonstrate the failure to include this fact in the probable cause affidavit warrants a Franks hearing. Defendant has not demonstrated law enforcement omitted it intentionally or recklessly, nor has he shown how including the information would have affected probable cause. One simply cannot say that. Had law enforcement included a statement that Dylan, unsurprisingly, was unable to recognize the defendant from a photo, the magistrate would not have found probable cause. A Franks hearing is not warranted on this issue. In Issue 4, the defendant takes issue with Exhibit A insofar as it describes the suspect vehicle captured through various surveillance cameras. It states law enforcement officers provided video footage of suspect Vehicle 1 to vehicle specialists within the Federal Bureau of Investigation. Okay, this is when they're talking about the vehicle and how they identified it. Hold on one second. I just want to make sure that we are still on here. Yeah, good. And defendant claims there are two material and exculpatory omissions in the paragraph about the car, and that the erroneous use of a video. So the court finds the defendant challenges are unsupported by his proffer and do not warrant a Franks hearing. Defendants claim that the FBI specialist felt more comfortable setting the year range of 2011 to 2013, and law enforcement knew their specialist was of the opinion the car was also certainly between 2011 and 2013, is based on an email chain between the specialists, Agent Anthony Amell, and another FBI agent about their investigation. However, the email chain does not support his argument. What the email chain shows is that on November 26th, 2022, Agent Amell directed the FBI to open up their search to 2011 to 2016. In doing so, he discussed the changes to the Hyundai Elantra in 2014 and 2017, and he stated that he wanted a better shot of the vehicle's front fog lights and rear reflectors. He further added, rather not leave anything out, better safe than sorry. 5 minutes later, he sent another email stating, yeah, I see the change in 2014, and I'm not really a fan of the 2014. I much prefer the 2011 to 2013, but wanted to lay that out. Have a good night. We'll keep looking and send any new info I can come up with. These emails demonstrate that it was Agent Amell's decision to open the date range to 2011 to 2016. Let's see. Despite his preference for 2011 to 2013, Exhibit A accurately captures this decision by stating that the specialist initially believed it was a 2011 to 2013, but he opened it up to 2011 to 2016 upon further review. While Exhibit A did not call out that Agent Amell preferred the narrower time frame, the defendant has not shown this omission to be exculpatory and material. Considered as a whole, it cannot be reasonably concluded that Agent Amell's preference for a narrower date range would have derailed the magistrate's finding of probable cause had it been included. Probable cause is not an exact science and does not require that law enforcement establish with absolute certainty that the facts alleged in search warrant affidavits are in fact true. Okay, let's see now. It's about the Elantra again. The River Road footage. There is no evidence. Okay. Defendant has not met his Frank's burden. Defendant notes that in Payne's... That's the IgG stuff. A review of camera footage indicated that a white sedan, hereafter suspect vehicle 1, was observed traveling westbound on Steiner Avenue at Idaho State Highway 95 in Moscow at approximately 3:28 a.m. On this video, it appeared suspect vehicle 1 was not displaying a front license plate. Okay, so about the dog barking. Defendant contends that Detective Payne failed to include 3 allegedly important pieces of information pertaining to the dog. 1. That the dog heard on the security camera continued to bark for 30 minutes after the suspect left. 2. That Detective Payne conducted a test to determine that the dog was likely outside while barking. And 3. That Murphy was found without any blood on him, even though the bedroom doors were open where the defendants were found. According to the defendant, this omitted information would have revealed that whoever was in the house brought the dog back inside after the suspect vehicle left. He further argues that this information is material and exculpatory because it undermines the narrative and timeline that supports probable cause. However, defendant's argument assumes without proof there were no doors left open in the home after the suspect left. This assumption is not only speculative but contrary to evidence in his proffer, and the sliding glass door to the residence, the same door towards which Dillon reportedly saw the suspect walk, was left open. Thus, if the dog heard barking was in fact Murphy, it could well have come back inside through the open door and gone into Ms. Gonsalves's room on his own, where it evidently remained. There is simply no evidence to adopt the defendant's speculation that someone brought Murphy inside after the suspect left the residence. Consequently, the defendant has not shown that the failure of law enforcement to so speculate was a material and exculpatory omission that would intentionally or recklessly exclude a Frank's hearing is not warranted on this issue. The geofence. Defendant challenges the 1-hour turnaround from when law enforcement received the return on the first AT&T warrant and submitted the application for the second AT&T warrant. According to the defendant's expert, Thomas Slavinsky, it takes 1 to 2 days at a minimum to secure call detail records from AT&T and then convert, analyze, and peer review them. He surmises that the fact that Detective Payne was able to complete these tasks in 1 hour means the FBI had already secured and analyzed the information and provided their analysis to Detective Payne, who simply reported to the magistrate that he was told without telling the magistrate the truth about how the investigation truly unfolded. Franks does not contemplate such conclusory accusations. Mr. Slavinsky was not included in the investigation, and his attempt to impute untoward conduct to law enforcement lacks any foundation. As Detective Payne testified at a prior hearing in this matter, he received the return from the first AT&T warrant and immediately turned the material over to the FBI agent Balance to begin deciphering it while Detective Payne started on the second search warrant application. While the defendant may wish to cross-examine Detective Payne on this issue, it is not a basis for a Franks hearing. Further, even if the FBI had already secured the records prior to receiving the return of the first AT&T warrant, the defendant has not shown how the inclusion of this information in Exhibit A would have negated probable cause. A Franks hearing is not warranted. Defendant has not shown the alleged misstatement regarding when the defendant's phone stopped reporting was intentionally false or exculpatory. Defendant next asserts that Detective Payne misrepresented the time of the defendant's call. The cell phone stopped reporting to the network to imply that the defendant was traveling towards Moscow between 2:47 and 2:54 a.m. when he was not. Memo, page 25. On this point, the defendant relies foremost on the affidavit of his expert, Mr. Slavinsky, who states, Affiant has found inaccurate information in Officer Payne's affidavit for the search warrant and application for an order for a pen registry or a trap and trace device. Payne makes a false statement in his affidavit. Payne states in his affidavit at approximately 2:47 a.m., the 8458 phone stops reporting to the network. This statement is erroneous. Payne has failed to advise the court of the following. The 2:47 a.m. traffic is a continuous 7-minute stream on multiple towers that ends at 2:54. Payne does not document this 7-minute traffic. Payne did not inform the magistrate about these handoffs, which would have clearly and directly shown him the fact that on November 13th, from 2:47 to 2:54, Mr. Kohberger's device was not heading to Moscow as purported by Payne, but was indeed heading southbound from Pullman, Washington. The fact that Payne either disregarded or was not aware of the handoffs and direction of travel of Mr. Kohberger's device gives this affiant grave concern over the lack of training and experience Payne has in mobile forensics and the credibility of his affidavit. Defendant's other cellular expert, Cy Ray, likewise contends that he has reviewed multiple search warrant affidavits prepared by Detective Payne, and his statement that the defendant's cell phone stopped reporting to the network at 2:47 a.m. is blatantly false and not supported by the AT&T data. In addition to these two expert affidavits, the defendant includes in his proffer the AT&T call detail records that purportedly revealed that the actual time the phone stopped reporting to the network was 2:54 a.m. As an initial matter, the defendant has not provided the search warrant affidavit identified by Mr. Slavinsky with his proffer. The only search warrant affidavit authored by Detective Payne that the defendant has provided was his proffer, is Payne Exhibit A, which is dated December 29, 2022, and accompanied an application for a warrant for the defendant's arrest. The court cannot consider the effect the alleged misstatement would have on probable cause without the correct affidavit before it. However, the search warrant affidavit referenced by Mr. Slavinsky is otherwise part of the record in this case as to other motions, and the court will take judicial notice of it for purposes of deciding this issue. Let's see. The court does not find the defendant's proffer deserving of a Franks hearing. First, the defendant has not established the challenge statement is a misrepresentation. Detective Payne expressly qualified his statement by noting it was an approximation only. What is Mike asking? I want to know if they tested the 2 for pot. Panic attacks, a little weed will do it, my thoughts. Okay. Excuse me, I just don't think they have any involvement. Sure, they both regret. Yeah, I don't think the girls have any involvement. I don't think so. I don't think so at all. Further, even if the statement could be characterized as false, the defendant has not shown it to be intentional or reckless. In fact, not even Mr. Slavinsky goes so far as to impute this means to be intentionally or recklessly so. In fact, not even Mr. Slavinsky goes so far to impute this mens rea to Detective Payne. Rather, he points out that Detective Payne either disregarded or was unaware of the handoff that would have revealed the correct time the phone stopped reporting. Based on Detective Payne's self-described lack of expertise in analyzing CDRs, it is reasonable to infer the latter, which amounts to, at most, negligence. Further, Detective Payne relied on Agent Balance to decipher the CDRs, which he is entitled to do in executing probable cause affidavits. Finally, the defendant has not shown Detective Payne's mistake in identifying the handoff data to be exculpatory. Mr. Slavinsky claims it was exculpatory because a correct interpretation of the data would show the device was not heading to Moscow as purported by Payne, but was indeed heading southbound from Pullman, Washington. There are two problems with this assertion. First, the pen register affidavit represents the device was traveling south at 2:47 a.m. when, according to Detective Payne, it last reported to Witt. Okay, so let's see here. Talking about the weight. Okay. During the processing of the crime scene, investigators found a latent shoe print. The detected shoe print showed a diamond-shaped pattern, similar to the pattern of a Vans-type shoe sole, just outside the door of Dylan's bedroom, located on the second floor. This is consistent with Dylan's statement regarding the suspect's path of travel. The defendant contends that the last sentence is false, noting that the footprint is closer to her bedroom door than she reported the suspect to be. There are no other prints before or after it, and it is not positioned towards the sliding glass door, which is where Dylan said the suspect walked after passing by her. Its only purpose, defendant further claims it is an intentional or reckless statement because its only purpose was to corroborate Dylan's unreliable statements. There is nothing false or misleading about Detective Payne's statement. The shoe print was consistent with Dylan's account. She told law enforcement she saw the defendant walk past her bedroom door after she opened it for a third time. Dylan's bedroom door is immediately at the landing of the base of the stairs leading to the upstairs bedrooms. The shoe print was therefore reasonably within the suspect's path of travel as described by Dylan. Further, the first footprint was located only in one spot, and there were not any others before and probably going to say after, right? After. It does not make Detective Payne's statement false about the path of travel. Consequently, the defendant has not shown Detective Payne's statement was false or otherwise misleading. Oh, I just want to make a quick announcement. This is important. Who has heard about Scamanda? Scamanda. It's a documentary series. It's on Hulu. It is about a cancer scammer named Amanda who lived out in California, and she got married. She was a stepmother and then had 2 babies with this guy. I know you have. But we are watching that, members and Patreons, after this. So if you're a member or a Patreon and you want to watch Scamanda, you can join us. I'm just saying that. So if you're not a member or a Patreon, you can easily become a member very easily. Nightbot will give you that. But it helps support the channel. We do have a trial coming up. Trial now is going to be set for June or July, to be determined. And that was the hearing. We had a pretrial hearing on Thursday. And that is the outcome of that. Just saying, okay? And I will be doing after I watch the whole Scamanda documentary, I will be doing a review and reaction to it, okay? Good. All right, now let's see. There is nothing false or misleading about the shoe print was consistent, blah, 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 blah. I think, okay, so it says, she told law enforcement she saw the defendant walk past her bedroom door after she opened it for a third time. And then I opened the door again, and the guy is right there. I think he was walking past my door and saw me, I would say. He was about 3 feet away from her. Excuse me. Dylan's bedroom door is immediately at the landing of the base of the stairs leading to the upstairs bedrooms. The shoe print was therefore reasonably within the suspect's path of travel as described by Dylan. Further, the fact the footprint was located only in one spot, and there were not others before and after, it does not make Detective Payne's statement false about the path of travel. Consequently, the defendant has not shown Detective Payne's statement was false or otherwise misleading. Additionally, the defendant has not established that Dylan's interview statements were wholly unreliable as discussed supra, or that there was otherwise a need to bolster her credibility in the magistrate's eyes through false corroborations. Consequently, even if the shoe print was not totally consistent with the DM's account, the defendant has not demonstrated that this statement was made deliberately or recklessly. Moreover, the defendant has not articulated how excision of the statement would have any bearing on probable cause. In fact, it would not. A Frank's hearing is not warranted on this issue. Okay. So this other one, let's see, he says, information about the timing and scope of information obtained and relied upon. Everyone is, okay, he's talking about the DNA. Defendant has not established when law enforcement knew of the lack of victim DNA in the defendant's vehicle and apartment. The 3 ISP lab reports relied upon by the defendant were issued on March 2nd, March 8th, and May 23rd of 2023. Thus, it cannot be said that law enforcement knew of the lack of DNA until the last report was issued. The defendant has not provided or identified any search warrant affidavits submitted after May 23rd, much less explained why the lack of DNA was material to probable cause for those warrants. In his reply, the defendant claims that the actual testing for the DNA was performed by ISP long before the 3 lab reports were issued. He asserts he has reason to believe that the results of the testing were verbal, transmitted to law enforcement at the time. Hey, thank you, Mike. Thank you so much. That's very nice. And I'm not going to delete it like Gail, but I'm going to heart it. See, I can heart it. Very nice. Thank you. Sorry to call you out, Gail. Okay. I'm just teasing you. First, defendant submits the ISP lab notes from lab report 28 and claims that the testing was done February 13th, 3 weeks before the report was actually issued. Defendant submits lab reports from a hair and fiber analysis performed by the FBI. The first lab report, dated January 27, 2023, revealed the hair and fibers collected from the crime scene were not consistent with the defendant's hair sample. The second lab report, dated February 28th, revealed that the hair and fiber samples collected from the defendant's vehicle and apartment were not consistent with the victim's hair samples. Again, this evidence does not support defendant's assertion that law enforcement knew of the lack of victim DNA in his vehicle and apartment. As best, it can be said that law enforcement was aware as of February 28, 2023, that the FBI's testing did not reveal the victim's hair fibers in the defendant's apartment or vehicle, but it is evident that the various lab reports that law enforcement investigation with regard to DNA was still continuing. Therefore, there was no basis for law enforcement to definitively Ever there was an absence of victim DNA in the vehicle and apartment till the final reports were issued. In other words, the defendant has not demonstrated an omission, much less that it was an intentional or reckless. Oh boy. Further, the defendant has not demonstrated how including this omission would have affected the magistrate's finding of probable cause. He contends that it would affect all warrants issued January 5th, 2023 and beyond, but he has not provided any search warrant affidavits from this time period for the court's consideration. However, based on the Payne Exhibit A that is included in defendant's proffer, the probable cause as of December 29th included, among other things, that the DNA profile obtained from the trash pull of the Kohberger's family trash was determined to be from the biological father of the source DNA left on the knife sheath at the crime scene. Given this evidence, no reasonable magistrate would conclude that the lack of victim's DNA in defendant's vehicle or apartment after the crime would negate probable cause. Thus, a Franks hearing is not warranted on this issue. Hello there, Heartmate Wives. Okay. In Issue 8, the defendant challenges law enforcement's omission in Exhibit A that the defendant was identified through an allegedly unconstitutional use of IgG. He contends law enforcement should have disclosed in Exhibit A that the methods used by Courtroom Labs to conduct the IgG testing allegedly did not meet minimum standards, that the FBI failed to document its much larger DNA profile, and that the FBI violated its own policy and that of the commercial enforcement use. Defendant contends these omissions from Exhibit A were purposeful. He also argues the omissions from material and exculpatory because they would have undermined probable cause by exposing law enforcement's false narrative of the investigation. As mentioned, the court permitted a full Franks hearing on this issue. The court's finding of fact on the evidence and testimony presented and its conclusions of law are fully set forth in its memorandum, decisions, and order on defendant's motion to suppress. Genetic information filed contemporarily herewith and incorporated herein, as the court determined in that order law enforcement's use of IgG to identify the defendant as a potential suspect was not unconstitutional. The court found that regardless of whether the FBI arguably contravened its own policy and contravened that of MyHeritage and GED Match with its when it uploaded the DNA profile to their databases, it was not of constitutional importance. Moreover, the defendant has not established that the search warrant affiants knew when submitting their respective Exhibit A that FBI or Courtroom did anything untoward in regard to the IgG searches. Okay, so this is all that DNA, and we heard it at the Franks hearing, right? About their saying that it was unconstitutional, yada yada yada. Let's cut to the chase. Defendant's identification through IgG evidence or the means in which IgG was performed had this effect. Indeed, had the IgG information been included, even with the problems complained of by the defendant, its only effect would have been to add to probable cause, not detract from it. Consequently, relief under Franks is not warranted. Conclusion: based on the foregoing, defendant's motion for a Franks hearing is denied. So we learned about this vacuum cleaner thing in here, and what else? That everything is no. Okay. Let's see what else we have. Okay, perpetrator. Let's see what this one is, the alibi. Okay, let's look at the alibi here. What is this? We didn't look at this one. Comes now, State of Idaho, by and through the Loudoun County prosecuting attorney, and respectfully moves the court in limine, oh my gosh, I can't even speak tonight, in limine for an order prohibiting defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. By way of background, the state's May 23rd, 2023 request for discovery disclosure alibi demand, the state's July 22nd, 2023 motion to compel, notice of defense of alibi or alternatively to bar certain evidence, the defendant's August 2nd, 2023 objection to the state's motion to compel, motive of defense of alibi or alternatively to bar certain evidence, the attached partial transcript of the August 18th, 2023 court hearing relating to the alibi where the then presiding judge, John C. Judge, observed that the defendant's proffered so-called alibi not really an alibi, and that he will address the issue of alibi disclosure in a subsequent scheduling order beginning at line 8. The August 22nd, 2023 scheduling order, which in paragraph 7 at page 2 addresses the deadline for the defense to comply with its statutory obligations for alibi disclosure. The scheduling order was subsequently vacated when the defendant waived a speedy trial on August 23rd, 2023. The state's December 21st, 2023 motion for scheduling order, which in the second full paragraph on page 3 refers to the issue of alibi. Okay, so the state's April 26, 2024 response to notice of defendant supplemental response to state's alibi demand, former presiding John C. Judge, June 27, 2024 scheduling order, which is subsequent to April 17, 2024 alibi disclosure deadline, which makes no further reference to the alibi. It has now been approximately 20 months since the state first made its request for discovery disclosure alibi demand. As the court file reflects, the defendant has failed to comply with the requirements of Idaho Code. The defendant has yet to specify the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such an alibi, as directed by the February 23, 2024 order setting deadlines and hearing. And as discussed in the state's April 26, 2024 response to the notice of the defendant's supplemental response to state's alibi demand, the defendant proffered April 17, 2024 notice of defendant's supplemental response of state's alibi demand does not comply with the requirements of Idaho Code or with the specific directive of the court's February 23, 2024 order setting deadlines and hearing. Consequently, the defendant should be prohibited from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. Even when the defendant, to attempt to comply at this late point in time, the state is irrevocably prejudiced. It has now been over 2 years since the homicides occurred and since the defendant was charged, and it would be unrealistic at this late date to expect the state to effectively investigate and respond to any new information, alibi-related disclosures. This is precisely the situation that caused concern for the Idaho Court of Appeals. In that case, blah, 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 blah. For these reasons, the court should issue an order prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. Okay. Let's see what this one is. Demonstrative exhibits. Let's see what this. Okay, so this is the state of Idaho. Standard of admissibility. A diagram offered for demonstrative purposes need only be relevant to illustrate a witness's testimony. It does not need to be precisely accurate, i.e., not to scale. In this case, the state anticipates introducing a three-dimensional model of the 1122 King Road residence. And this model would consist of 3 levels, which can be removed by level to show the interior layout of the residence. The interior layout will depict wall and door placements, no furniture or human depictions, etc. The model will be placed on a rolling table for portability within the courtroom, i.e., can be placed out of the way when not in use. The model is being constructed by the Federal Bureau of Investigation based on depictions, documentation, and measurements taken at the scene prior to demolition of the 1122 King Road residence. The primary purpose of this model is to aid the jury in having a better understanding of the layout of the residence, which is unconventional, and to illustrate where certain events occurred within the residence. The model will aid certain witnesses, i.e., law enforcement, surviving roommates, individuals responding to the crime scene, and crime scene analysts in demonstrating the location of victims, location of witnesses, location of items of evidence, items related to their testimony, path of travel, etc. The state anticipates laying the proper foundation to establish the model accurately reflects the layout of 1122 King Road. They put Kind Road there. The model passes the IRE 403 balancing test as the value of in facilitating the jury in visually understanding where facts in issue occurred at the crime scene far outweighs any danger of unfair prejudice, distraction, confusion of the issues, or waste of time. This model will merely aid witnesses. Testimony and is not being introduced to establish a certain fact in issue, therefore is not hearsay. The state requests the court issue an order allowing the state to use a three-dimensional model of the 1122 King Road residence, finding that the model is relevant in order to aid witnesses in their testimony, provided that the state lay adequate foundation for the demonstrative exhibit. So, and here's the picture of what they want to show here, this on the rolling table. And it would be 35 inches by 48 inches by 52 inches. It's quite large, right? Okay. Let's see here. Proper filing. Okay. Filing, signed, and noted in affidavit. See what this is about. Investigators in the courtroom. Okay, it's hereby ordered the defense shall have both of their investigators present during the trial, and the state shall have their lead investigators from the Moscow Police Department. That would be Brett Payne and Idaho State Police Sergeant Darren Gilbertson present during the trial without limiting their ability to testify. Okay, so they're going to be in there the entire time. Let me see here. Let's see if we missed anything of any importance that we missed. Let's see. Let us see. There are okay, somebody. Okay. Trying to see if there's any information that we should go over. So let's see what this is. State of Idaho. Motion to modify no contact order. The State of Idaho, by and through Latah County Prosecuting Attorney, moves this court for a modification of the no contact order previously filed herein, prohibiting the defendant from having any contact with the father of one of the victims. This motion is based on the fact that the father has requested the addition of his wife and stepdaughter to the no contact order. The state has contacted the defendant's attorney, Ann Taylor, in this matter, and she does not have an objection to amending the no contact order to include the wife and stepdaughter. Okay. Trying to see what else. Okay, hold on 1 second. So I told you that Steve Gonsalves was on News Nation and said that they had not been given a heads up that any of this stuff was coming out, right? Okay. Words defense wants banned: murder, psychopath, sociopath, bushy eyebrows. Let's see. Just trying to see if there's anything else. Rumor? No. Has anyone seen an explanation of why Dylan texted the Uber driver who was driving K and M home that night? Don't understand that part. K and M. Okay. Let's see. So here they say that in the case at bar stating on November 13th, Dylan sends a text message to E.G., the Uber driver, to inquire if he is driving. The state submits the text message exchange as not hearsay because it will not be offered for truth of the matter asserted, i.e. E.G.'s driving status. Instead, it would be offered to show a timeline for the night, i.e. Dylan was awake and texting at 2:10:29 and from 4:19 to 4:21. Right, and again, here's the text, okay? At 4:22 to 4:24, Dylan to Bethany, no one is answering. Dylan to Bethany, I'm really confused, RN. Dylan to Kaylee Gonsalves, she says, Kaylee? Dylan to Kaylee, what's going on? Then Bethany to Dylan, yeah, dude, WTF? Bethany to Dylan, Xana was wearing all black. Dylan to Bethany, I'm freaking out, RN. Dylan to Bethany, no, it's like ski mask almost. Bethany to Dylan, STFU. Bethany to Dylan, actually? Dylan to Bethany, like he had something over his forehead and little end mouth. Dylan to Bethany, BF, I'm not kidding. I am so freaked out. Bethany to Dylan, so am I. Dylan to Bethany, my phone is about to die. F. UCK. Bethany to Dylan, come to my room. Bethany to Dylan, run. Bethany to Dylan, down here. And then, what do we have here? Okay. Let's see. Still trying to see if there's anything that we've missed here. Oh, you know what? Hold on a minute. You know what I want to look at? Hold on. Let's look at, hang on. Let me go to, hold on, I'm going to get a video. We're going to watch a video for a second. Just hang on. Nothing, I'm just getting a video for them to watch. I want to look at something here. I'm just going to source this. Okay, let me see here. All right. Show all. Okay, here we go. I want to Second Indiana. Okay, so let's look at this. I'm going to pull this one up. It's only 2 minutes and 40 seconds, so you'll be okay watching it. Come on, stop the video. Stop. I want to pull it over. All right, let's watch. Let me rewind it back. This is the first traffic stop when they were on their way driving to Pennsylvania, and it was on December 15th.
Recording.
Hello.
How you doing?
How y'all doing today? Good, good. Take a look at your driver's license real quick if I could. See, it's right up on that van, man. You right up on the back end of that van. Hold you over for tailgating. Is this your car? Okay. Cool. Where are you headed?
Well, we're coming from WSU, and we're scanning
What's WSU?
I go to university, basically. They were listening to this incident that was occurring up there, this shooting incident. That is SWAT team and everything.
So we're, okay, I'm having a hard time hearing you because of the traffic. So you're coming from Washington State University?
Yeah.
And you're going where? Oh.
We're going to be going to Pennsylvania.
Oh, okay.
Open mountains. Yeah. So we're slightly punchy because we're driving for hours.
Hours, days.
Hours. We're driving. Well, almost a day.
Okay. And what did you say about some SWAT team thing? Or
Yeah, there was a mass shooting and everything.
Where?
This was on essentially municipality.
Interesting.
Well, it's horrifying because it's supposed to be the universe, you know what I mean?
So y'all work at the university there?
I actually do work there.
Oh.
PhD in criminal
Okay. Okay. Yeah, I hadn't heard about that incident. Just yesterday, or?
This happened this morning. About an hour and a half ago. They're still wrapping it up. Investigating. I'm not sure there's two shooters because they did shoot somebody.
Let's see.
And then
We don't know about that actually. They were there, they were shooting out of the window or something.
Interesting.
They said
Wow.
suspect.
Okay. So do me a favor, don't follow too close, okay? All right. Thank you. Appreciate you.
All right, let me get the other one now. Hang on. That was the first. And then we're going to see the second.
What does it feel like to step into the Athens 2? Kinda like that.
Okay.
Walton State Police, got your license and registration with you. I realized I stopped you, man, when you were driving by me there, you're a little too close to the back of that semi. You're about one car between you and the back of this trailer. We're about one car length for 10 miles an hour, so if you're going 60 or 70 miles an hour, we're about 6 or 7 cars. Oh, you guys did?
Yeah, and you said that so
You guys stopped by a trooper? We don't have any SUVs. It was a county guy. Was it like a black SUV?
Yeah.
Okay, all right. And you thought you guys were following too closely? Okay.
What happened to WSU when my son goes to school shooting?
Today? Well, I'm not going to give you guys another ticket or warning if you just got stopped. Just make sure you give yourself plenty of room, okay? So like I said, it's all about how fast you're going, okay? So if you're going 10 miles an hour, you only need one car. Right? If you're going, so the speed limit here is 7. If you're going 70 miles an hour, you need 7 cars. Yeah. That's the easy way to explain it. Yeah. Okay. It's really, if you're in the B&B man, it says 2 to 20 seconds. All right. You guys have a safe trip. Where y'all headed?
Thank you so much for stopping.
Where y'all headed to? Huh? Where at? PA? It's a long haul. You guys scared of airplanes? Did you? Okay. All right, well, hey, you guys have a safe trip.
Thank you,
See you.
sir.
So there's his vehicle. So he's watching Brian's vehicle right there. Driving. Oh, wait a minute. He's pulling him over. Why are we doing this again? Is this... Do I have... This is odd. Why are we doing this again? Oh, unless they're showing both views of this. This is from the car, and then the other one was from the officer. No, it's two different views of the same stuff. One for the car camera and one from the police officer's body camera, which we saw before when we kept seeing his shoes. The traffic noise is ridiculous.
the last time you had a vegetable?
Why can't we stop this? Oh my goodness. Okay, let me get rid of these now. Okay, so now we have to talk about the DNA under the fingernails. So I want to get that. If that's the one we have to talk about that one still. Let's see. Where is my index? Here we go. Okay, let's see. So Monday. Where's the DNA? Redacted. Let me see if it's this. Nope, not that one. Okay. Denied. Okay. Not that one. We've already done the death penalty. Autism. Expert testimony. Okay, what is this one? Okay, so these are the experts that are going to come in. Let's look at this. The defendant, Bryan Christopher Kohberger, and counsel Ann Taylor, comes now the state. Here we go. The state is providing the following supplemental responses. So this is for the state's amended supplemental response to request for discovery regarding expert testimony. 1. Jenny Ayers. 2. Nicholas Balance. 3. Taylor Mashak. Tara Martinez. Jade Miller. Ann Nord. Rylan Nolan. Eric Seat. Paulette Sutton. Tina Walthall. Catherine White. Stephanie Wilt. Haley Younglin. The state is awaiting additional information it has requested and will finalize supplemental responses for the outstanding experts. Once completed, those supplements will be filed promptly pursuant to the court's instruction. Okay, so those are that. Let's see. Affidavit. Nothing there. So I'd say it's going to have to be, it says it was run out on Monday. Let me find exactly where it is. Okay. Okay, here it is. Let me just see where this is from. Okay, in limine number 5, inconclusive data. Let me get this. In limine number 5, inconclusive data. All right. In limine number 5. Here we go. I've got it. Let's look through this one. Bryan Kohberger, blah, blah, blah. Okay, so he's talking about by and through his attorneys, and hereby moves the court for an order limiting testimony about the statistical analysis of item Q13.1 fingernail scrapings. Allowing such testimony would violate Mr. Kohberger's federal and state constitutional rights to due process, a fair trial, effective assistance of counsel, and confrontation of witnesses. This motion is based on the 5th, 6th, and 14th Amendments to the United States Constitution and the Idaho Constitution, Article 1, Section 13, and Idaho Criminal Rule 16, and Idaho Rules of Evidence 102, 104, 701, 702, 703. The requested limits are made to secure fairness in administration to the end the truth may be ascertained and the proceedings justly determined. Further, the above requested matters are ripe for consideration by the court pursuant to IRE 104. In the grand jury testimony, Jade Miller, that's one of the experts, testified as to the result of the testing done on item Q13.1, a swab of the left fingernail clippings from Madison Mogan. The data consisted of three-person mixture. The statistic, the likelihood ratio LR, was calculated assuming that Madison was a contributor to her own fingernails. Miller testified that Madison, and that's redacted, the data from the sample was redacted as to Mr. Kohberger. And let's see, Miller testified that inconclusive means that an analyst is redacted, and to explain the likelihood ratio for Mr. Kohberger. The use of misleading language confuses and misleads the finder of fact and is barred by the rules 402, 403, as well as due process, in that the evidence is overly prejudicial. The erroneous admission of irrelevant and prejudicial evidence will offend due process when it renders a trial fundamentally unfair. Here, expanding beyond the language of the report would prejudice Mr. Kohberger in that it might allow the jury to infer that the inconclusive data would mean that he might be included. LRs are different than traditional statistics that courts and juries are used to seeing and hearing. The LR is a comparison of hypothesis. It is not a statement of identity or probability of identity. It simply asks the question, given the data, which hypothesis tested is more likely? For item Q13.1, both hypotheses tested for each individual assume that Madison's DNA was present. So when the lab generated an LR laid out above, the hypotheses tested were Madison, Kaylee Gonsalves, and one other unrelated person versus Madison and two unrelated persons. The comparison was done for all of the individuals listed in report number 7 and for Mr. Kohberger in report number 26. At the ISP lab, any number greater than 100 is considered a conclusive result, indicating inclusion. Any number less than 0.01 is considered a conclusive result, indicating exclusion. This, what are you doing, Desi? Thus, if a LR falls within the range of 0.01 to 100, the lab cannot draw any conclusions and the data is reported as inconclusive. In her testimony, Miller did not provide a full context to the analysis. The lab reported a series of LR for item 13.1, including an LR of 0.399 for, and that's redacted, 0.485 for redacted, and 0.20 for redacted, and 0.223 0.022233 for redacted. Lab report number 7 at 3. All of the individuals sit in the same shoes as Mr. Kohberger, namely that the LR is exclusionary but falls in the range of inconclusive. Of interest is that when an LR was calculated for redacted, thus Mr. Kohberger's inconclusive LR is similar to almost every other person for whom an LR was generalized, and focusing on his inconclusive LR would mislead the jury, in that it implies that the LR means that Mr. Kohberger's DNA might be present in the sample. The court should exclude testimony such as blah, blah, blah. Most importantly, Mr. Kohberger has disclosed that through further independent laboratory testing, he is eliminated as a contributor to item 13.1. When Mr. Kohberger sought to overturn the grand jury indictment, he argued that Miller's testimony was inadmissible and misleading. The state argued that the testimony was presented to the grand jury as exculpatory and an effort to elicit favorable evidence for Mr. Kohberger. The independent lab testing conducted by the defense related to item 13.1 is indeed exculpatory. Mr. Kohberger is excluded, and the state should be precluded from misleading the jury in any way. Conclusion. A fair trial is mandated by Mr. Kohberger's federal and state constitutional rights to due process. A fair trial, effective assistance of counsel, and confrontation of witnesses. U.S. Constitution Amendments 5, 6, and 14. Idaho Constitution 1, Sections 8 and 13. Expert testimony improperly elicited must be excluded. Okay, hang on for me 1 minute. I've got to take a 2 ibuprofen. My head is killing me, and I've got to take it so my headache I don't get a really bad headache. So just take a stretch, get a drink. I'll be right there. Hold on a minute, guys. Somebody took the ibuprofen. I'm gonna have to take an Alibi then. Alright, let me take an Alibi. What's the matter, Jasper? Lulu. No, you don't want. They think I'm getting a treat or something. This is an Alibi, and this is not acceptable. You cannot have that. No, no. No. Nope. No. Try my drink over there. Oh, you cannot have this. Nope, you cannot have this. Mm-mm. Oh. Sorry, my dogs want I have 3 dogs and Lulu's jumping on me. Okay. Hi, Lulu. Lulu. Oh, stop, Lulu. Damn. Here. I don't think you even like that. See? You don't even like that, do you? I gave her a little bit of a key lime. Cookie. She doesn't. Let me get them their bones. Come here. Come on, you guys have your bones. Let's definitely have your bones. Let's get you a busy bone. Come here. So you can go get busy somewhere. Here you go. Come here. Wow, you guys are almost through this package. Dad's been giving you too many. Take it. Here. Wow. That's crazy. That's actually the big size too. That's nuts. Okay. Sorry, I'm coming. I'm coming over here. We're gonna look at some of the other, there was something else I had to look at. Some other news story I had to look at. Okay, guys. Let me look at something here. We're going to look at, see what else is going on in the world. Now, a lot of you, I'm going to do it again because I said it in the beginning and maybe you weren't here. We're going to talk right away about Gene Hackman and his wife. A lot of speculation went around, a lot of really crazy stuff. But what happened was the hantavirus. The New Mexico officials announced on Friday that both Gene Hackman and his wife died of natural causes. Heather Jarrell from the Office of the Medical Examiner's Chief Medical Examiner said Hackman, 95, died of heart disease, while his wife, pianist Betsy Arakawa, 65 years old, had hantavirus pulmonary syndrome and tested positive for hantavirus. Alzheimer's disease was listed as a contributing factor in Gene Hackman's death. I'm sorry. Hackman and his wife were found dead on February 27th. His wife was discovered on the bathroom floor in the same room where pills were scattered on a countertop. Hackman was in the mudroom with sunglasses at his side. The couple's dog, which was a Kelpie mix, was found dead in a kennel in a bathroom closet. The two other dogs were found alive on the property. Early on, police debunked rumors of carbon monoxide poisoning, noting there was no evidence of a gas leak. They also noted that there were no signs of forced entry, despite the front door being open. On Friday, the Santa Fe County Sheriff Adam Mendoza said surveillance footage and other data indicated that Arakawa died around February 11th, and Gene Hackman died around February 18th. Santa Fe, New Mexico, reported that about 3 to 4 cases of hantavirus are reported annually. In the Southwest, the virus is deadly in 38 to 50% of cases. It's the hantavirus. Okay. Oh, this is just great. Well, I feel like I know this lady. She looks like somebody that I know. A 15-year-old Wisconsin boy has been charged as an adult with stabbing his mother. And he says he was inspired by the Menendez documentary. Let's see here. We've got... Okay, let's look at this. Let me get this document, okay? Oh, be quiet, these stupid ads. Okay, let me get this up here. Okay, so here's the first page. State of Wisconsin criminal complaint versus Reed Galinsky. The above-named defendant, on or about Tuesday, March 4th, in the village of Caledonia, Racine County, Wisconsin, did cause the death of S.G. with intent to kill that person, contrary to section blah blah blah, and upon conviction shall be sentenced to imprisonment for life. The official records and files of the Racine County District Attorney's Office, the Wisconsin Department of Justice, and or Department of Transportation reflect that the defendant has the following record of convictions. The complainant, being first duly sworn on oath and on information and belief, alleges and states that in the County of Racine, State of Wisconsin, the defendant did commit the above described offense and prays that said defendant be dealt with accordingly to the laws of the state of Wisconsin. The complainant states that he is an adult citizen and has reviewed the official law enforcement reports prepared under the above-mentioned complaint, numbers by the above-stated officer, whose reports your complainant rely upon as truthful and accurate inasmuch as they were prepared during the course of an official law enforcement investigation. The complainant relies upon the statements of the mentioned witnesses inasmuch as they are citizens and their statements are based on personal knowledge or eyewitness observations. That complainant relies upon the statements of the defendant, if any, insomuch as they are contrary to the defendant's penal interests and are therefore to be believed. Hold on a minute. Get my other page. Hold on. Hold, please. Okay. Let me bring this down just a tad. Okay. This is the second. Officer Corey of the Caledonia Police Department reports that on March 4th at approximately 10:30 p.m. he was dispatched to the 10,000 block of White Manor Court in the village of Caledonia, County of Racine, State of Wisconsin, for a report of a juvenile who stabbed his mother to death. The complainant advised that she received a Snapchat photo from Reed Galinsky showing a female laying face up on her back. The complainant also advised she saw a Snapchat photo with blood on the floor and prior statements from Galinsky stating that he needed help and that he stabbed his mother to death. Galinsky was transported to the Caledonia Police Department where he was interviewed by Detective Schuster. During the interview, Galinsky stated he came home from school on the above date and felt depression and an urge to kill his parents. Galinsky said he had been taking his brother's anxiety medication for about a month, and during the night he took approximately 9 pills, and that it does not help his anxiety, but it makes him high, and he enjoys that. Galinsky stated he searched the home for a hammer because he was going to kill his father when he came home from work, but he could not find one large enough. Galinsky then said after dinner his mother, S.G., was seated on the couch using her computer, so he started watching a movie. He said he then turned on the Menendez brothers documentary on Netflix. Galinsky stated he then developed the plan to kill his parents. He stated it came to him while he watched the shotgun scene. Galinsky advised his mother went upstairs around 9:50 p.m., and that is when he got up and hid his sleeping medication. He said after hiding the medication, he grabbed a steak knife and put it in his pocket. Galinsky stated he then went up to get S.G. and told her he couldn't find his medication. Galinsky said he hid a dumbbell bar in the sleeve of his sweatshirt. While S.G. came downstairs to look for the pills, Galinsky stated while his mother's back was to him, he hit her twice in the head with the dumbbell. Galinsky said he thought she would fall over, but she did not. So he threw her to the ground, and he grabbed the knife. Galinsky said she tried to kick him off of her approximately 7 times, but eventually he stabbed her 3 times in the chest and twice in the neck. Galinsky stated his mother asked him why, and he replied, pain. Upon arrival, officers observed a male exiting the house. The male was identified as Reed Galinsky. As officers approached Galinsky, he dropped a brown and silver kitchen knife at the front stoop of the home. He then made statements for officers to kill him and stated, "She's dead, and she is dead from what I did." Galinsky was taken into custody, and officers noted his clothing appeared to have blood on it. Galinsky later made an excited utterance stating he struck his mother over the head with a dumbbell in an attempt to knock her out so that he could stab her with the knife. Officer Christensen entered the residence and located an unresponsive female, identified it as SG, on the ground in the foyer near the front entrance with apparent stab wounds and blood-soaked clothing. Officer Christensen attempted life-saving measures, as did the Caledonia Fire Department. However, SG could not be revived. SG was transported to the Milwaukee County Medical Examiner's Office for an autopsy. Officers later collected the kitchen knife dropped by Galinsky at the front stoop. There was blood on the knife and handle of the knife, on the blade and handle of the knife. Another kitchen knife was located near the kitchen sink. The knife had a drop of blood on the handle and blade as well. A silver adjustable dumbbell bar was also located next to the cabinet near the refrigerator. Hang on, we got it one more page here. Maybe more than one. Hold on, please. Okay, so that was page 2. He said pain over here. Yeah. Okay, so we were on page 3. After the attack, Galinsky stated he contacted his friend via Snapchat and told her to call the police. He said he sat on the floor until he heard sirens. Galinsky stated once the sirens stopped, he went outside to investigate. SG's preliminary autopsy findings show the cause of death was multiple sharp force traumas to her chest that caused severe internal bleeding. The doctor who performed the autopsy indicated that SG's wounds and injuries were consistent with a homicide. Wow. And this kid was, what did I say? He was 15? 15 years old. 15 years old. And I guess then he didn't get his father, right? He made his first court appearance Thursday afternoon, and he was ordered held on a $1 million bond. What the heck? Where was his dad? Because it was late. His dad worked a night shift somewhere, maybe? I don't know. Missing 13-year-old. Did they find this little girl who's missing in... Let me see. Let me see if they found her. Sometimes we get good news. Let's see. Did anybody find this little girl? Let me just see. 13-year-old Lillian Asala. Let me see. She's been missing since Saturday in Wisconsin. Oh, she was found safe 6 hours ago. That's good news. It's good news. It wasn't looking good if she's been missing since Saturday, but it says she was found safe. So let's see where she was for all that time. What's been going on? Right here's the girl. Let's search. It's good news. I didn't think it was going to be good news because I believe they said her phone was found dead. And what is up with this? Why? Okay. Where did that go? Well, let's try that again. Lillian Asala was located safe by members of the Oak Creek Police Department, according to an update from police on Friday. Dozens of volunteers gathered at Bender Park Thursday to continue the search for signs of the 13-year-old. Lillian was last seen March 1st, Saturday, at a skate park in Oak Creek. Her family said she left without any of her belongings. After text to Lillian's phone went unanswered, the family called the police. See. All members came out, generously offered labor, printing, footwork, and was actually, I'm getting a little emotional because it was a really good outcry of community support, says Lillian's great uncle. And then she was found. Where was she found, though? Police say they will release further information on the investigation, which remains active when possible, but confirm that there is no active threat to the community. Well, at least she's safe. So that's good news. See what else. Bond denied for Donna Adelson. Oh yes, I want to look at the bond denial of Donna Adelson. I want to look at the official bond denial. Let's take a look at Donna Adelson's denied bond document, okay? Come on, Donna. Get over there, Donna. What are you doing, Louise? What you doing, Louise? Hey, don't scratch, you silly. What? What? Want to be petted? Hear your voice. Okay. All right, let's see now. Come over here, silly. You want to come over here? Here. I don't have any. You're not getting any more bones. No. That's enough treats now. You guys have a lot of treats. All right, let me go over here and grab Donna Adelson's denial of her bond. Denial of her bond. Where is your bond? Here we go. Oh, the Adelson's family home is for sale. Let's take a look at the family home that's for sale. Here we go. 9909 Coral Springs. Surprised they are in Coral Springs and not Parkland. Julia, Caldwell Banker. Zillow. Let's take Zillow over there, okay? Guys, what are you doing? Hey, come over here. What are you doing? All right, here it is. 989.9. I almost bought a house in Parkland or Coral Springs. They're right next to each other. Back in 2004 or something. And that was at the height of the market, and they were high. This is like, seems low for the property, but I don't know. Let's see. Wow, that look, you know what that looks like? Hold on, tell me what that looks like to you. I'm going to check the chat. I'm giving you a moment to put it in what that looks like to you. What does that look like to you? I'll tell you what that looks like to me. I'm going to the chat now to see what you've said. Dina Elizabeth, I hope you're feeling okay. She was not feeling well. Where's Lasso Lacey? Our new moderators. Okay. It looks like it looks like a hotel lobby. It looks to me like a dental office, like a medical office, like a big giant medical office or something. That's what it looks like to me. But this looks like a reception area where you go, hi, I'm here. Are you here for your 4 o'clock? Like, what the heck is going on here? That really looks like a dental office. Not very. Look at that place. I don't know if they took the Adelson stuff all out of here and this is staged, but that tile is really dated on the floor. Very dated. Extremely dated. Kind of looks like Charlie Adelson's place. Look at that. Look how dated that like kitchen set is with the rolling chairs. Oh yeah, I know that's a mirror, but I'm saying it gives you the impression. And the Formica office. Yeah, it is very dated. We have a sauna. Haley. Haley? What is this about? Why does it say Haley? Who's Haley? Who's this for? I'm lost on this. What's all the kitty stuff in here? I'm gonna have to find out about this. Oh my gosh, look at the orange. Okay, let me see what's going on with this. Hold on. So this is the home Wendy, Charlie, and Robert grew up in. So it says Harvey had a tennis court and fencing added in the backyard. It languished for a few years after the ace sold in... okay, wait a second. This is for sale. It's their home, but they sold it in 2015, and the new owners took out the tennis court that Harvey had put in. They had it demolished in 2017. So this was sold. This is for sale again, but this is not right from them at all. Okay. So let me see. Here's Donna Adelson. Denial of bond. Okay. So, order denying motion to set bond, the Arthur hearing. The cause came before the court when the defendant sought review of her bail status based upon State versus Arthur. The court, having reviewed the evidence admitted during the February 26, 2025 hearing, the arguments of the parties, the court file, and otherwise fully advised in the premises, finds and adjudges as follows. Let's get Donna up on the screen again for this. The defendant is charged by indictment with a qualifying offense, first-degree murder, and the state has come forward with a showing that the proof of guilt is evidence, or the presumption is great. The evidence from Charles Adelson's trial, viewed in the light most favorable to the state, demonstrates 1. The defendant's personal and unique motive to assist, cause, or encourage the murder of Dan Markel. 2. The lengths the defendant was willing to go to in the custody battle involving her grandchildren. 3. Testimony by Catherine Magbanua directly implicating the role of the defendant in the payment of the murder for hire. 4. Payments made by the defendant to alleged co-conspirators following the murder. 5. Text messages and cell tower analysis demonstrating the defendant's movements on the night of the murder. And 6. The defendant's conduct after the law enforcement bump operation and communications on authorized wiretapped interceptions. Defendant also exhibited consciousness of guilt when she attempted to flee to Vietnam prior to arrest using an emergency fast-track visa. The evidence of flight is admissible as consciousness of guilt where sufficient evidence exists to establish the defendant fled to avoid prosecution. After the state meets its burden regarding Arthur, the court still retains the discretion to grant or deny bail. When determining this issue, the burden is on the accused to demonstrate the release of bail is appropriate. It is with regard to this question that consideration of the likelihood that the accused will flee regardless of the sureties required becomes appropriate. In reviewing the evidence admitted during the hearing and applying the bail criteria of Section 903.046 Florida statutes, the court finds that one of the primary considerations of bail, ensuring the appearance of the criminal defendant at subsequent proceedings, cannot be met. One day after Charles Adelson was convicted of first-degree murder and other crimes, the defendant discussed fleeing to countries without extradition to the United States. That same day, the defendant communicated with the Vietnam visa, Indochina Sun travel through what she believed was a secure communication application, WhatsApp. trying to acquire a fast-track emergency visa for Vietnam and wanted the fastest she can get it. The purchase of a one-way ticket and seeking a fast-track visa for her extended stay in a country without extradition clearly demonstrates an intent to flee. The court does not find the testimony offered by the defendant during the evidentiary hearing on this subject to be credible. Considering the evidence, additionally, the defendant's discussions of harm further negate the possibility of appearance for subsequent proceedings as directed by the court. The issues raised by the defendant concerning her conditions of confinement can be directly addressed through administrative and/or civil remedies. The testimony and evidence during the hearing clarify the reasonable measures taken by the Leon County Sheriff's Office to address the defendant's concerns. The defendant is not being denied access to counsel or the opportunity to prepare for trial. The court also notes the defendant has undergone extensive trial preparation prior to the continuance of the trial on September 17th of 2024 through the present. Done and ordered in Chambers, Leon County, Florida, Monday, March 3rd, 2025. Denied, Stephen Everett. Sorry, Donna. You're not going home. Your home right now is Tallahassee. And you just hate that, I know. She is not liking Tallahassee, right? She did everything to get her grandchildren out of Tallahassee. Tallahassee is not where she wants to be. Okay. Hi, cute kitty kitty. How are you? Alrighty. Now, let me check what else is going to go on right now. I feel like I know that guy. Okay, so that Slender Man stabber. Let's see what we got here. Morgan Geyser was granted conditional release from a psychiatric facility in January. Morgan Geyser committed to a Wisconsin psychiatric facility for brutally stabbing her best friend to impress a mythical online creature at the age of 12 is set to be released. Geyser, who's now 22, admitted in 2017 to stabbing Peyton Leutner after luring her into the woods during a sleepover in 2014 in order to appease the mythical internet figure called Slenderman. Geyser's co-defendant, Anissa Weir, was also convicted. She was released from the same psychiatric facility in 2021. In January, a Wisconsin judge, One-Eye Blind Arts? Hope you're okay, One Eye. Ordered Geyser's release after experts testified that she has made progress during her time at Oshkosh, Wisconsin facility. She's done what she's supposed to do, said the Waukesha County Circuit Judge Michael Boren. She appears to have a good attitude. Despite the judge's confidence in her release, Geyser briefly faced a halt on the decision after the facility hosting her discovered her jailhouse readings and communication with a man outside the institution. The reading material that she's so focused on has themes of sadism and murder and the sale of human organs on the black market. Deputy District Attorney Abby Nicole argued all of these things that the treatment team at Winnebago had no idea that she was interested in. Her lawyer, Tony Colton, said in response that Geyser herself declined to have contact with the man in question and that she was not reading anything that hadn't been vetted by authorities already. Dr. Kenneth Robbins, who previously testified on Geyser's behalf, dismissed concerns about her release after the revocation petition against her release was filed last week. Boyrin on Thursday sided with the testimonies in Geyser's favor, noting in his last ruling that the new information did not change his mind. I don't see a risk to the public. I don't see a risk to her, Boyrin said. I'm satisfied the state has not met its burden. So she will walk free. Okay, and then I think I said this too, but it was early in the evening. Okay, a South Carolina man became the first person executed by a firing squad in the United States in 15 years, after his last-minute appeal for clemency failed. Brad Sigmund, 67, was scheduled to go in front of a row of sharpshooters Friday evening. He spent nearly 25 years on death row following a conviction in the 2001 murders of David and Gladys Lark, his ex-girlfriend's parents, who he killed with a baseball bat. Sigmund's execution was South Carolina's first undertaking using a firing squad since the state Supreme Court ruled the practice was legal in July of 2024. The state legislature legalized executions by firing squad and electric chair in 2021, but it was blocked by a lower court the following year. Hey, guys. Come here. Get over here. Stop, you two. Goodness, what is up with you guys? Guys, if you guys didn't go down to puppy place, what are you doing? Oh my goodness, you've got like the zoomies. What is up? Where do you want to go? Where are you going? Where are you going? It's bedtime. You gotta go to sleep. Gotta go sleep. Gotta go sleep. Okay. On Tuesday, Sigmund had previously elected to die via the firing squad instead of lethal injection or the electric chair. Who would choose the electric chair? That's like... Oh, let's see. They're 15 feet away. There's 3 shooters. There's a target on his heart. And it went through. And I heard that his ex-girlfriend, whose parents were killed, said, to remember her parents. So, yeah, that was that. That was done tonight. Firing squad. Let me see where you guys are. Yeah, where is Nelson? I'm going to have to do some checkup on our people. Make sure everybody's all right. Okay. All right, let me go. to I forgot to put my thing there. All right, I think then, let me see what's going on. Let me come to the chat and talk to you guys for a second. Then we're going to play the word game. Oh, thanks, Al. There was a boy missing for 7 years found today. Oh, that's good. You like a leaf better? For a headache, you like a leaf better? All right, let's do the word cookies. So after this, we'll watch Scamanda. So if you want to watch Scamanda, go get your stuff. Shoot, this is not the daily. We need to go here to get the daily. This is super easy, isn't it? That was so super easy. That was not even funny. That was so super easy. Hi, Murder of Crows. Hi, Murder of Crows. That was so super easy. Okay, got that one. And we got one up here. Uh-oh. I lost you guys over there. Woke? Okay. Yes. All right, thank you, Heart. Okay. Let's play one more game. That was a really easy one, too. Very easy. Hold on, I've got to just do something really fast. Okay. All right, so I had to do something very important. All right, let's go back to this. Aim. Right. I do. Okay. Where are you? Hi, it's just me. Amen. Yeah, amen. Very good. And Anel. Very good. Very good, Gail. Oh, men. Yes, men. Good, Gail. Good, Gail. And I don't think it's going to be there. Enigma, very good. It's just me. I guess, yeah. Very good. Heart Made Wise says, no, can't do aiming. It's only one eye. Mange. Yeah, you mangy mutt. I'll put you in the ASPCA. Very good. Maine, I don't think is going to be there because I don't think they do proper nouns. Meaning, very good. Murder of Crows. Meaning, you got it. The meaning of life. Perfect. Thank you, Murder of Crows. Oh boy, let's see. How about naming? I got that one. Yay. Okay. Mean. You're mean mug. You're mean mug. Yeah, that's good. Very good, Murder of Crows. Oh, name, I got, yeah, we have name. Nang? 9. 9 is good. Thank you, hi. Oh, mega roll, yeah. Gem. Gem, you're a gem. Yelby. Thank you. Diminish. That was easy. That was very easy. Prayer. Very good, hi. Harry. Very good, hi. Riper. Pairer. That one, payer. You say Perry? Oh. Two words I'm thinking, I know. I know what you're thinking. Paper? No, there's only one R. I mean, there's only one P. Oh, repay. Very good. We did it. Okay, we'll stop there. Thank you guys so much for watching. Thank you so much for hanging out. I appreciate it so much. Thank you for the super chat, Mike. I appreciate that so much. Thank you for everybody that watches the replay. Thank you so much for the super thanks. And I appreciate it very much. Thank you so much for joining membership, Patreon, and supporting the channel in any way you can. It's very appreciated. Everybody have a good night. God bless and prayers. Thank you so much. And members, I'll put out the thing for the movie.